Good evening. Welcome to tonight's episode of Aging with Attitude. My name is Phil Koch. I'm the host of the show. And tonight we have a friend of mine from the industry, the senior care industry, who's an elder care attorney, or elder law attorney, forgive me, Jennefer Gairity. Welcome, Jennefer.
Thank you very much.
Well, first of all, why don't you tell us and our viewers tonight what elder law is?
Elder law is a wide expanse of the law, but generally speaking, it incorporates the estate planning portion of things, wills, trusts, powers of attorney, and also the long-term care factor. And sometimes that includes things like guardianship, long-term care planning for where living, what living arrangements there are going to be, and looking at Medicare issues, Medicaid issues, sort of all those things wrapped into one.
Right. A little bit of everything, huh?
Yes.
Now, as an elder attorney, do that designation mean another type of law? Do you need to go to a special school or a special certification to specialize in that area, or no?
Law school doesn't have any particular specialty. You graduate with a degree, a Juris Doctor, a JD as a graduate of a law school. Mm-hmm. But there are specializations and there are board certifications in various categories, and elder law is one of those categories.
Wow. And you have a partner as well. How long have the two of you been doing this specialized area?
We started Gairity and Gossage in 2006. Right. It was interesting. Both of us at different times participated in the elder law at Wake Forest, which it was the only elder law clinic at the time in the country. And now it's, there are elder law clinics in many law schools throughout the country. But it's something that both of us had a passion for and were interested in from the very beginning.
Wow, that's cool. So tell me more about estate planning and long-term planning, how that all works, and your thoughts.
The estate planning piece of it includes making sure the appropriate documents are in place. And it's really important for everyone, not just older adults, but for everyone to have advance directives in place. Those are the documents that control things if someone loses capacity or cannot make decisions for themselves while they're alive. A lot of people are so focused on the will portion of it, they forget about this piece of it that really has an effect on how things are done while you're alive if you're not able to make those decisions for yourself. So we have healthcare power of attorney and living will. Those two things sometimes are part of one document, sometimes are separate. But the healthcare power of attorney designates someone to make decisions for you in the event that you can't make healthcare decisions for yourself during your lifetime. So, surgeries, medical decisions, those types of things. It also includes things like where you might live if you don't have capacity and you need to be in some sort of facility. The living will says, these are my specific wishes. We get a lot of discussion about, do you want to be hooked up to a machine? Do you not want to be hooked up to a machine? Those are the types of things, tough questions, but things that can really make a difference in that end-of-life scenario. So those two documents work together. Then there's also a financial power of attorney, which does the same thing except for financial transactions. And so it designates someone, and preferably an alternate, to make financial decisions for you during your lifetime if you can't. So those documents are sort of the during life wishes being expressed. Then the will and some sort of will trust combination takes care of what happens after you pass and where your assets are directed at that point. So that's the estate planning portion of it. The elder law piece of it starts with that, but then we look at, what are your wishes for long-term care? If you need care, whether it's in the home or somewhere else, what are your wishes and how are you going to pay for it? And that's a big deal.
Yeah. Well, let me ask you, going back to the healthcare power of attorney and the living will. This is a question, I'm in the industry, but not in law, but I've always been wondered about this. Let's say, and you have a living will, but you nominate somebody for a healthcare power of attorney, and then somebody becomes incapacitated, and the living will says one thing, but the healthcare power of attorney thinks a different way. Which one oversees the other?
I'll give you a good legal answer. It depends.
Okay, right, fair enough.
You can be very specific in the documents as to whether or not you want the living will factor, the living will decisions to control, period, end of story.
Right.
Or you can say that the healthcare agent has some discretion in ultimately making that decision. So that's important. In filling out and completing your documents. It's important to understand what you're putting in place. But the most important thing is making sure you designate that person, that agent who's going to be making decisions for you. Make sure they're going to be able to carry out your wishes.
Right.
So make sure they know what you want and that they're going to be able to do it. You know, I tell clients all the time, when they say, well, I'm going to name my oldest and then my next and then my youngest in that order because I don't want any feelings to be hurt. This isn't about feelings getting hurt. This is about making sure healthcare decisions that you want are made. And not everybody is going to be the best at doing that, because if we're looking at when someone's going to be called upon to come into making those decisions, it's going to be emotional.
Yeah.
If you care at all about the person who you've been designated for, it's going to be an emotional situation, and everybody may not agree as to what should happen. And so it's really important to designate someone who you've told and talked to and made sure they understand what your wishes are, but also that they'll be able to step up and carry out those wishes at an emotional time.
I think that's a very good point. I've seen it myself quite often. Also, let me ask you a question on this. I see a lot of families that will designate, if there's 4 children, they'll say, well, I don't want to hurt anybody's feelings, so everybody's going to be power of attorney, which is on the financial side, let's say a financial power of attorney. And then when something happens, trying to get a consensus sometimes amongst the 4, or whatever the number is sometimes very difficult. What are your thoughts?
Whenever possible, I strongly encourage clients to name one first.
Yeah.
You can put all of them in the document if you want to,
Right.
but as alternates. Because for the very reason you pointed out, whether it's on the healthcare side or the financial side, if they don't all agree,
You're in stalemate.
you're in stalemate, exactly.
Yeah.
On the healthcare side of things, you want, if a decision needs to be made quickly, you want somebody to have that authority to make the decision and go forward if you need treatment. On the financial side of things, there's not often that urgency, but you still need to be able to get things done.
Right.
And so I always encourage clients to do one and then the other,
Right.
and however many there are. Or if they're absolutely set on having co-agents, to somehow have somebody have the authority to break the tie, if you will.
Right. And let me ask you something else, because I see this sometimes where seniors are afraid to nominate anybody as financial power of attorney because they're saying, I don't want to give anybody that power right now. And as I understand it, correct me if I'm wrong, they still have the final say, correct? I mean, if they nominate their son as power of attorney and they're still completely coherent and can make decisions, their say is, or no?
Again, it depends.
It depends. Okay, I'm sorry. Go ahead.
The best way to protect that, if you have any concern whatsoever, you have a lot of clients who say, just like you pointed out, I'm not ready to give that up. I want to keep the reins as long as possible. We do have the ability to put in place what's called a springing power of attorney. And so what that means is it does not go into effect, meaning there is no authority under that document until a physician or physicians, depending on what the document, how we write the document, but until a physician says this person lacks capacity to make financial decisions, it's now time to call on the agent. But that way, you don't have to worry about somebody stepping in too soon.
Right.
I do have a lot of clients who say, you know what, I want my son to be able to help me write checks and help me even though I can still do it. I'm kind of done with that.
Right.
And so we have the ability to do either way.
What about so we're talking about advanced directives is kind of the big umbrella term that covers all of these topics, right?
Correct.
So when we talk about advanced directives to our seniors and to the loved ones with the seniors, it covers the broad spectrum, and under that is a will, a living will, healthcare power of attorney, financial power of attorney, what else?
Potentially trust or
long-term care planning. So.
Anything that's putting in place now. I mean, just what the word says, advance directive. It's directing now what's going to happen in the future.
Tell me what you hear. We're hearing this topic more. The MOST form. What is this, and how does it impact our seniors?
The MOST form is similar to a do not resuscitate or a DNR form or order, but those are orders that are done through a physician. So those are not, they are legal documents in a sense, but they are not something that an attorney prepares. They are something that you have the conversation with your physician, and the physician signs off on what those orders will be. The DNR is specifically do not resuscitate. It's very, very limited in the scope. The MOST form is something that has been in place much shorter period of time,
right.
But it gives you much more opportunity to be more specific with regard to what your wishes are.
Okay.
So, again, we go back to the healthcare power of attorney and the living will. You can put some specifics in that, but that might be done long before you really have any need for care.
Right.
Whereas the MOST form is something that really is done once you have a need for care, and so you can be a lot more specific on what things you do or don't want at that particular time.
Right, right. So let's say Mrs. Jones just moved down from Michigan or whatever state. She moves into North Carolina, and she says, because you get this a lot, gee, are my advanced directives pertinent now in North Carolina, or should I get it checked out by an attorney, elder attorney? Your suggestions?
It depends. But I would always recommend having them get it checked out by an attorney here.
Yeah.
Every state has different rules on what an advanced directive has to include, especially with regard to the signing and notarizing part of it. So, for example, in North Carolina, a healthcare power of attorney living will has to have 2 witnesses and a separate notary. So, if a document comes from another state that only has a notary or only has witnesses, while the law says if it was valid in that state when it was created, it should be valid here, the practicality of it is it's going to be difficult, or you might run into problems when you go use it, because somebody at the hospital isn't going to know what the law in Michigan was. They're just going to know what North Carolina requires. And so they're going to say, this isn't notarized, we can't accept it. And so in that situation, I always recommend redoing the document here in North Carolina.
Okay.
But there are lots of times, depending on how it's been created in other states, as long as it is not going to run into any issues here in North Carolina and it still does what they want it to do, they can be perfectly fine from another state.
In North Carolina and South Carolina, there seems to be some
Reciprocity?
Reciprocity, thank you very much. In many areas. Now, is that the same thing when it comes to elder attorney issues? I mean, or no?
It's still not. From a legal standpoint, there's separate licensing for North Carolina and South Carolina. So I can't legally help. I'm not licensed in South Carolina.
Right.
So I can't legally help someone who is a South Carolina resident. We do have someone now in our office who is licensed in South Carolina.
Oh, perfect.
So I can say, I can't help you, but
somebody else can.
Larissa in our office can. The laws are different, and most of all, the licensing is different. So even if I knew what the law was in South Carolina, I'm prevented ethically and with my law license to be able to do anything for someone who is in South Carolina.
So if somebody came to you and said, and they're asking advice, and they said, should I have the same person be my executor, my power of attorney, and healthcare power of attorney? Your thoughts, other than Well, I know it's coming. It depends.
It depends.
Okay, all right.
The thing I tell clients for healthcare, it can be the same. Let me go back. I'll answer your question first and then I'll explain it. It can be the same person. It doesn't have to be.
Yeah.
But the real criteria is who is going to be the best person for that job.
Right.
So we talked about the healthcare for a little bit. Who's going to be able to understand what your wishes are and make sure those are carried out. That person who can do that for healthcare may not be the same person who is good with finances or handling money. To name someone who you want either to handle the financial power of attorney or the executor, oftentimes those tasks align a little closer. But you want someone who has similar ideas on how you handle your money.
Right.
I mean, you don't want someone who just spends money at the drop of a hat if you're very conservative.
Right.
This is someone who is going to be controlling your finances. So you want someone who is going to be able to understand what your needs are and be careful with your resources.
Right.
Because as we know, long-term care can be very expensive. So you want someone who's going to be able to look at the big picture and make a good decision for you. The executor side of things, my personal opinion is that the executor really has the least important role of all of these that we're talking about, because one, the person's already passed, so their well-being is no longer an issue. You don't you don't have somebody making decisions that are really going to affect quality of life. But secondly, the role of the executor is very limited. They have to follow the law of North Carolina and they have to carry out the will. And for any assets that pass through probate, the court is monitoring what happens with those resources.
Right.
So it's a much smaller role, in essence, than the other roles. But still, you want someone who you trust, who's going to do what they're supposed to do with those resources.
Right. Now you hear, with regards to a will, there's the big picture, and there's money, and there's trust, and there's, obviously the money side of it, the houses and assets, et cetera. But let me bring up a topic that I've seen come into play, at least from my vantage point, watching clients, and that is, of course, the big assets and the money, et cetera, needs to be settled out. But it seems like so many arguments come over an ashtray, which monetarily might not, or whatever the case may be, might not be so much money, but it means so much to two of the siblings, maybe even more. Your thoughts?
Personal property, which is what that, jewelry, household furnishings, decorations, those types of things, knickknacks, invariably become a bigger issue.
Yeah.
And it's because there's not a value. Sometimes there is, but more often than not, when we're looking at household items, the sentimental piece is much greater than the actual monetary piece. There are a couple ways to handle that.
Mm-hmm.
One, you can itemize everything in your house and designate who that goes to. Chances are that's a little cumbersome. I think the better way to do it is if there are certain items that you know that you want somebody to have, spell that out. And then have the conversation with whomever you're leaving things to and say, listen, I don't want this to be a big deal. If there's something that you really want, tell me. I'm not promising that I'm going to give it to you, but if there's something that really means something to you, let me know.
Yeah.
And I can either include that or not, but at least that person knows. But if you have the conversation with everyone who may inherit and just say, I don't want this to be a fight.
Right.
This is how it's going to be done, and do me the favor of not fighting over it.
Because the last thing you want to do is, God forbid, yourself pass one day and your siblings fight over an ashtray, or whatever the case may be.
Exactly. And I do have to say sometimes to heirs, and it's probably not my place, but just say, listen, you're not honoring the person who just passed. Mm-hmm. Don't make this about you. Let's move on. Let's be adults about this and figure out a way to make this amicable.
Right.
Doesn't always work.
Doesn't always work, yeah.
But the more specific that you can be in the documents that you leave, whether it's in a will, whether it's in a separate writing, whether it's, tagging different items in a house, the more specific you can be, the less chance that there's going to be issues.
Yeah, my parents, which I thought was interesting, they said, okay, go through the smaller items and make a list of anything that you want, and then we all sat down and said, okay, does anybody also want that item? And if so, we're going to talk about it. And I thought that was kind of good because we worked out, there were a couple things that both my sisters wanted, for example, and we worked it out, and so that hopefully when the day comes, it won't be an argument.
And that's the thing, when you can get it done ahead of time, when there's not that emotional component to it, nobody likes talking about it, I get that.
Right.
But if you can do it without the grieving emotional component to it, it usually goes a lot smoother.
Right. So, talking about wills, do they need to be updated every now and then, or no? Depend on the state. Depends.
It depends. Sorry. A good rule of thumb is to think about any major life change.
Right.
Pull it out, take a look at it. Does it still do what you want it to do? But
Right.
is there a birth? Is there a death? Is there a wedding? Is there a divorce? Is any big change? Does that affect what you've put in place in your will? And if you look at it every 5 years or so, or when there's a big event, life change, then just check on a couple of things. Can the executor still serve? Is that still the person that you want, who you want? And how are things distributed? Does it still take care of what you want? Does it do what you want? Can it still happen according to what's in the will? And if it does those things, then you probably don't need to update it. But
Okay.
it's good to check it periodically. You'd be amazed at the number of folks who come in and they say, yeah, I thought so-and-so was my executor and I named Uncle Bobby. What was I thinking?
Right.
I don't want that anymore.
Right.
And so, you make a change because you forget what you do if you haven't done it in a long time or haven't looked at it in a long time. And things change.
That's
so
true.
It depends. If there have been major changes and if there is something that doesn't work anymore,
Yeah.
then it needs to be changed. But there's no automatic, yes, it needs to be changed every 5 years or 10 years or whatever.
Here's something I've always wondered. So if there's 3 children and you say I leave the same percentage share of my assets and money to all 3 children, but let's say you don't want, do you have to stipulate that would only go to the daughter and not the daughter and husband, or future husband, or vice versa?
Typically, it's spelled out who that's going to.
Okay.
And if something happens to that particular person, what happens then? So in many situations, clients want to give everything in equal shares to their children. Mm-hmm. But if one of their children predeceased them, they want that child's share to go to that child's children. Okay. So essentially their grandchildren. That's a very common way to do it. But there are some situations where maybe they didn't have any children or some other situation, and so they would say, well, if that person dies, then I want it to go to their spouse, or I want it to be divided between the other children. But
Right.
it has to be very specific. There's no sort of automatic deferral unless you've spelled it out.
But if you said whatever the percentage goes to my son, and the son is married to a woman, or vice versa, it's a daughter married to a husband, does that spouse get any part of it because they're automatically married to that?
No, but once that person has inherited the money,
Right.
then that spouse is going to benefit from that most likely, because it becomes part of their assets at that point. And the will doesn't control anything once that distribution is made.
Okay, gotcha. Okay. Tell us about jewelry and things like the real things that you might have in a safe, heirlooms. You touched base about it a little bit earlier.
Again, be
Yeah.
specific.
Yeah, specific.
Because those are the things that there's usually interest in. They do have some monetary value potentially, and you want to just make sure those go to whom you want them to go.
Right. What are I mean, you've been doing this a number of years now, and you're, by the way, very well known in the industry,
Yeah,
her firm. When problems occur, what would be the more common problems that maybe our viewers could take an understanding of now and try to avoid?
Two things that we see that can very easily be avoided. One, get powers of attorney in place.
Right.
Because if you don't have powers of attorney in place, you have to go the guardianship route. And that's a court proceeding, it's emotional, it's expensive, it's time consuming, and it may not be what you want.
Right.
I mean, ultimately, who makes decisions may not be the person who you wanted to make decisions.
Right.
So if you get powers of attorney in place, 99% of the time that solves that problem. The other side of things is be specific in your documents as far as your will or your trust. Make sure those documents are doing what you want to accomplish.
Right.
And the more specific you can be, the better things are going to be. And also, as in your situation, let people know. Let your family know that you have those documents in place, that where the documents are, and generally what they do. You don't have to go into all the specifics, especially on the will, but make sure everybody knows that you have done that and those are your wishes, and you hope they'll carry them out.
Yeah, that's
Have a
so
plan.
important. Have a plan. Put it down. Where should they keep it? With the attorney and anywhere else? Copies of
The best thing to do is keep them in a safe place. It can be a safe deposit box at the bank. It also can be in a box, some sort of fireproof box at home. We don't keep documents. You pay for them. I think you should have the original documents, but make sure that they're safe and that the people who are the executor, the agents, they know where they are.
Perfect. Way to that concludes a very, very good evening with an elder attorney who's very well known in the Charlotte area, Jennefer Gairity. Thank you for being a guest on our show.
Thanks for having me.
Thank you for everybody out there for viewing the show tonight, and please stay tuned for upcoming episodes on Aging with Attitude, Channel 21, servicing the Charlotte and surrounding markets.